All right. Good afternoon, everyone, and welcome to today's Energy Safety Canada webinar with the Fair Practices Office. Today we have Brandy Madison and Tom Currian presenting. Now, of course, just as always, before we get started, a few little housekeeping tips. Please do interact with us. Please focus any questions that you have to me. I can consolidate those and provide those to our presenters. Or we will have a Q&A at the end of this presentation. You should see in your Zoom window at the bottom, there's a small chat icon. If you click on that, that will open a message that you can direct to me, your host, please. Alternatively, if you're on a mobile device, you can click the three buttons for more, and then either raise a hand or chat. Further to that, in case we have any basic yes/no questions from our presenters, you can click on the participants button, and then that'll open some options for yes, no, go faster, slower, or those types of audience responses. Just to test that functionality and make sure everybody can hear and see the presentation today, if you'll open up that participants pane and if you can both see and hear this presentation, please click yes. If not, click no, and then one of my co-hosts, either Adria or myself, will get back to you. All right, and I do see a lot of green there, so we're in good shape. Thank you so much. All right, now today from the Fair Practices Office, we have Brandy Madison. Brandy is the branch manager for the Employer Appeal Advisors, and she is formerly from the WCB, where she had various roles as case manager, claims resolution case manager, appeals advisor, and employer advisor. In addition, we have Tom Currian. He is the appeals advisor at the Employer Appeals Branch, and again, formerly with the Alberta WCB in employer accounts, underwriting, and the Office of the Appeals Advisor. So thank you so much for joining us today. I know this was a webinar we had to reschedule a couple of times due to, well, maybe some changes with the office that you'll get to hear shortly. So, all right, with that, I think I will turn this over to your presentation. And Tom, I think you're going to start today.
Actually, no, Brandy's going to.
Oh, Brandy's starting. My apologies.
Just need you to put up our presentation.
Oh, yep, sorry, there it is.
All right. Good afternoon, everyone. My name is Brandy Madison. I am the manager of the Employer Appeals Advisors, currently with the Fair Practices Office, but given Bill 47 recommendations, we will be moving to under the Appeals Commission. But that does not affect any services that we provide. If anything, it's just going to make them better. You can go to the next slide. So we always like to tell people the Employer Appeals Advisor service is independent. So we're independent from the WCB. They don't have any say in what we're doing or how we represent employers, which is really important. So we can act as essentially the advocate for the employer. So we are experts. The whole team has been doing this type of work for over 10 years, so 30 years of combined experience, not only in claims, but also a wealth of knowledge on employer accounts that Tom brings to us. So, and another thing is we're free of charge. And so although we always say to employers, you pay the premiums, and so we're not essentially free, but you don't get a bill at the end of our services like you do in some other cases. So it's a perk that you have as part of your premiums is that we're here to help employers with claims, appeals, and general questions, as well as account related matters. Next slide, please. So what we do, so we provide advice. So that can look like somebody, an employer calls us and they're like, this is what the WCB is telling us. We're not really sure if that's correct or not. Um, can you provide us some direction? Of course we can. We provide employers direction all the time. We also do a lot of education. We understand that this is not an employer's main bread and butter. WCB is not where, most employers are focused. And so if we can provide any sort, we get a lot of employers coming to us saying that they didn't report the injury, or, they didn't wear their safety boots. And so it's just about providing the education around, no fault insurance, as well as just what the legislation reads in order, for a worker to claim an injury. And then we can also dig down into the actual file and see, is there some merit to what the employer has brought to us. We also provide formal representation. And so what that means is, if you come to us with a concern that, WCB has made a decision on a claim and you don't agree with it, you can let us know that and why. And so we get the file from the board and we go through it. An advisor will have a conversation with the employer about what they see on the file, what direction they should go. So next right steps. So we start with resolution. We don't want to pull the whole issue to the appeals commission. Our goal is to start with resolution. And so getting some sort of resolution off the start saves a lot of time for the employer, as well as a lot of cost through the system, which the employer is ultimately responsible for. And so if there's any way, we put a lot of work up front to try and get your issues resolved with customer service. If it's not possible, then we will move to the DRDRB. And sometimes we've actually quite a bit, we're successful there. And ultimately, if we need to go to the appeals commission, which is the final level of review, we will take it there and we will write the presentation. We will do all of the, footwork on behalf of the employer and just ensure that, the right case is being put forward. And we'll also tell you, if there isn't a case. And so sometimes employers come to us because they're frustrated with the way that they've been treated by the WCB. The WCB hasn't listened to them. Unfortunately, those aren't appealable issues, but we can be an ear to listen. And, if there is anything on that file that we see needs an extra set of eyes, we can send it back for you. We do find that one of the biggest things is cost relief for employers. WCB, employers will come to us with, claim acceptance, and really the issue is cost relief. And like the WCB is not very good at making sure that the employer has, making sure that the cost relief has been reviewed before that claim is closed. And so there are claims coming to us that are closed and the employer should have been entitled to cost relief. So that's something that we would put forward on behalf of the employer. And so if you leave with anything today, it's, I want you to leave with the fact that we're here to help, and especially in this tough time for employers, anything that we can take off your plates as far as WCB matters that you have questions about or concerns about. We won't formally claims manage a file, but we will get involved if there's concerns. So next slide.
Actually, just two clarifications. One question, a clarification actually for me, Brandy, just for those who are maybe not familiar, in that escalation process, you mentioned that DRDRB.
Oh, sorry. Yeah.
For those who are not familiar, can you clarify what that is in that process?
So there's 3 levels of appeal. Like, we initially start with the WCB customer service, which is the case manager and the supervisor. If they are not willing to work with us and resolve the issue, we will move it to the dispute resolution and decision review body. That's the internal body that works within the WCB that reviews decisions. And so DRDRB. And then if we get a decision back that says, no, we're upholding, we don't agree with you, then our final level of review is the appeals commission. And so the appeals commission is where we would take it next. And the appeals commission is a pretty formal process. They say it's informal, but I think it's the most formal, informal process that I've been to. And it's really important for employers to have a representative at that level, because it's getting more and more complex and legalistic. And so we would recommend that if you're at that level, there's at least a consult with our department on what, you know, your plan is when you get there, and what have you.
Okay. And then just a follow-up question from the audience. Can you maybe tell us a little bit of the history of the Fair Practices Office? When was it established? How long has it been in effect? And I know that might be a tricky question because there were previous instances of what the group really was and what it was called.
Yeah, so previously we were the Office of the Appeals Advisors. And so workers were entitled to a service that basically now that I've just described, workers had that service for probably 30 plus years. So as a result of Bill 30 that the NDP brought in with all of the changes, they had requested the creation of the Fair Practices Office. The Fair Practices Office opened December 1st, 2018. And we had 4 different branches. And so we had Fairness Review, which they looked at administrative decisions, whether or not they were correct and fair, decisions made by the WCB. We also had a Navigating the System branch. And so they would triage, and if a worker or employer called and they were struggling with finances or anything that they needed, or a WCB issue, then Navigate could help them just navigate the system. And then we also house the employer's advisors and the workers' advisors. So we've been in business, well, it will be 2 years in December. And now, as some of you may or may not be aware, Bill 47 has now been proposed, and which takes away fairness and navigating the system and just leaves the advisors, and the advisors would go to the appeals commission. And so that's on, and there's also a lot of great recommendations in Bill 47 as far as I'm concerned from an employer's perspective. A lot of the changes that were made in Bill 30 are proposed to be reversed. And, you know, like the maximum compensation rate cap to be put back on, which I think is needed for a sustainable system. And also just, you know, presumption, psychological, that will be re-looked at just for first responders. And so there's a lot of, and then healthcare benefits, that employers wouldn't be required to, you know, continue healthcare benefits. And there's also duty to accommodate. And so although the employer does have a duty to accommodate, they're changing back the legislation so that, you know, fines cannot be levied by the WCB. And so, so yeah, that's some of the changes that are proposed, which I think are really good for employers, because we've seen a lot of employers struggle to meet the new demands. And so that's the history. And, you know, we're off to change again, which is, we're open to it. And actually, we think that this is going to be a great change for the advisors, because we're with a organization who really knows the system and knows how we work. And it's also very independent from them. They're taking us out of, you know, we're not with the appeals commission staff, we're on our own. And so, yeah, it will be a good move.
And I think the big piece for, you know, our audience today is that these services that were under the Fair Practices Office are still going to be available, albeit just reorganized.
Yes, yes. I mean, the fairness services and the navigating services will no longer be available, but our services for employers as well as workers advocates will still be available. And so, was there any other questions?
No, that's it for now. If you,
okay.
If you just want to continue on, I'm sure we'll get some more as we go.
All right. So just want to share a bit of what we see as far as in issues. So the top issues, since we we do trending reports each month. And so we compare our stats to the month before. And, you know, what we see for most employers is that they're appealing claim acceptance. So claim acceptance, I'll give you an example. We had a worker, you know, 4 years previously had a hip replacement. She had neuropathy as a result, so that's radiating down the leg. She was walking from her desk to the printer and tripped over her own feet. She put in a claim. WCB accepted that claim. Unfortunately, she did suffer some serious knee injury as a result. So the employer did some investigation with us and, you know, included some pictures of the carpet. Everything was in really good condition. You know, there's no extension cords in the way, nothing she tripped over. And so WCB was saying that it was just in the course of her employment, so this is acceptable. So we were able to show that there was no employment hazard. It was her own feet that she tripped over, and WCB denied the claim. So these, you know, this is just one example. There's several examples of claim acceptance where, you know, we had another one where the guy went into work saying that he broke his ribs, all of his ribs. But yet he had worked, you know, the 5 days prior to when he said it happened. So he said it happened on the Tuesday, and he worked Wednesday, Thursday, Friday, and Saturday, or sorry, no, Wednesday, Thursday, Friday, and his job was shoveling gravel, and so it was a very heavy job. And he actually worked overtime on 2 of the days, and the most overtime he's ever worked. And so WCB accepted that claim, and he called his employer on Sunday and said, you know, I've hurt myself. The employer knew what this guy's was like outside of work. So we were able to prove that that actually did not happen at work, and the claim was denied. But it was about asking the employer the right questions, right? Like, what did he work? Did he work any overtime? What was he like in those 3 days? And then just providing all of that evidence to the WC and letting them make the decision, which was in our favor. Cost relief is another one. And I have to say that this is not employers bringing us cost relief. It's about the fact that they've come with a different issue, and we find cost relief was applicable. And so in this case, a worker suffered a relatively minor fall off a trailer, injured his shoulder and back. The physical injury of laceration, contusion resolved within a few weeks. The worker had previous psychological issues that had now come up. As a result, the worker had not been back to work since falling off the trailer, almost 2 years. So as you can imagine, the cost of this claim would be quite significant. At last count, it was around $150,000. We were able to show that the aggravation of the pre-existing condition, so we were able to show that there was a pre-existing condition of his psych, and WCB agreed cost relief 6 weeks post-injury. So we got over $100,000 cost relief for this employer on this claim. You know, psychological is a big thing right now in claims and in general. And so these are claims where we are seeing that we're getting some success in cost relief because, you know, a lot of times there is some pre-existing condition stuff going on. And if you can prove it through medical, then cost relief would be granted. So the next one we're seeing is wage replacement. So temporary total disability. So we had, you know, we have employers come to us all the time saying, this shouldn't have been paid. We had modified work available. And so it's about gathering the evidence to prove that the modified work was offered. Modified work always needs to be put in writing so that you have that paper trail. It can't just be a conversation. If you can't get a hold of the worker, you know, make sure that you do your due diligence to send them a registered mail letter, whatever you need to do to make sure that you have shown your intent to get this to them. And so with this one, we, you know, look at the evidence and we try and get the wages removed as costs from claims where there's medical evidence to support somebody was fit for work, and you know, WC has paid it even though. And so yeah, that's another big one, and obviously it affects some of some associations from bidding on jobs. And so, this is a very important one to employers, and they don't want wage replacement paid if it wasn't needed to be paid. So next slide. All right, I'm going to turn it over to Tom now. Thanks, everyone.
Excellent. Well, thank you so much for having us today. And I guess we'll just sort of step in. So this slide is talking about the economic advantage of hiring our branch. So you'd already heard from Brandy earlier that we are free of charge, or no additional charge, as we like to say, right? Because ultimately we are supported from the premiums that employers pay to WCB. So you're not getting a bill from us at the end of the day. So what this is sort of for the numbers, for the numbers types folks in the audience, that basically what we're saying is this is by hiring us to help with a potential appeal, you are saving roughly pretty close to 2 weeks of effort from somebody. So we kind of break it down that it takes, sometimes depending on, now these are all just averages, right? But at the beginning, it probably takes a good 2-3 days to do a good file review. And we probably spend another half day or so in various types of discussions with WCB. We spend another couple of days dealing with the actual resolution submission. So that's actually writing it up and putting it together and, doing that. Now, one thing I wanted to sort of talk about is, before we move on to that, is how we like to work with our clients. So, even though we're the ones who are sort of doing all the legwork and whatnot, ultimately it's the employer's appeal. So what we do is before we do anything, we always work with you and get your approval. So for instance, if I were writing up a resolution submission, before it gets sent to WCB for their consideration, it goes to the employer first saying, hey, this is the arguments we want to make, and are you okay with it? And the reason we do that is ultimately, although it's us writing it up, it's your arguments that are being made, right? So we work very collaboratively with the employer. Next one, we have, we spend another probably good 2-3 days dealing with the actual appeals commission hearing itself. So that's, putting it together and writing it up and researching and presenting it. And then the last one there is actually attending any sorts of hearings. So that the first level that Brandy had mentioned, DRDRB, Dispute Resolution Decision Review Body, and then the next level, Appeals Commission itself. So the end of the day, we have about, that works out to about 9.5 days of effort. So basically a full paycheck of, whoever's on your company who would normally deal with it. So typically it falls to, health and safety people. And if you think about this, is now that's 2 full weeks they get to concentrate on their primary job duty as opposed to this. So significant savings as far as we're concerned. If I could have the next slide, please. Okay, so this one is sort of this is for our metrics folks. So this talks about some of the metrics and the deliverables. So what we commit when we get a file is just sort of 3 key dates that we use to help measure the success of our service. So the first one is we will contact, once the file comes to us, we will contact the employer within 5 business days to say, hey, we got the file, and sort of describe the beginnings of the process and what the sort of process looks like. So, and we find that for the most part, we are getting that, we're hitting that, well, we are hitting that metric 100% of the time. And in fact, we're doing it usually within the same day or the day after kind of thing. So, and why that's really good is I'm sure we've all dealt with other, outside of the appeals realm, maybe your, I don't know, your telephone service provider or something like that, where you send in a message and you don't hear back from them for days on end. And you always kind of wonder, well, did they get our message? And do I have to call again? So by us delivering it within, so at least right at the beginning, yeah, these guys have heard me and they're going to start looking into my case. Okay. The next metric is we will receive the claim file within 10 business days. So what that's all about is because Ed Brandy had mentioned, we are separate and independent from WCB, we don't share their computer system. So meaning that when you ask us to look at a claim, because you want to appeal something, first thing is we have to get the claim file. So we actually have to order it from WCB. and it takes their access to information people roughly 10 business days for them to put that package together and send it to us. So that's sort of that one. And then the last one is it says 30 business days to do an action plan. And what that's all about is now what's happened is, okay, so we've gotten the claim file and we've reviewed it. And now we're contacting you saying, okay, we've reviewed it and here's our recommendations. So like one of the things Brandy alluded to earlier is, our independence, and that how we have the ability to say to you, you know what, after a review, we think you have a strong case and here's why. Alternative to that, we also have the ability to say to you, well, you know what, unfortunately, we don't have a strong case and here's why. And why we think that that part is equally as important as people who are sort of in the business world, business side of things. You all understand above everybody else that time is money, right? So, do you necessarily want to spend 2 weeks, 3 weeks of your time dealing with something if it has no chance of success? So that's why we feel that that part is also very important. And it also serves as a one of our sort of pillars. It also serves as an educational piece, saying, hey, you know what, this is the way why this decision was made as it was, and maybe it helps you understand future decisions. If I could have the next slide, please. Okay, so this little guy is a nice little chart that we put together, and it's about the common types of accidents that are faced within the employers within your association. So what we did, a little background, is as you know, you are I believe you're one of the funded safety associations. And so we went on the WCB website and found all the industry codes that are attached to your association. And then we went into WCB. Oh, if you could, thank you. Yeah. And we went into WCB and pulled the statistics. So why I like to present this, or why we like to present this, is this gives you a little snapshot of where sort of the most common accidents that are facing your industry or your particular industries are, and what the dollar values are. And the one that jumps out, you can see right at the bottom there, is motor vehicle accidents. So what that's saying is, on average, when someone within your industries faces a motor vehicle accident, the average claim cost is roughly is about $43,000. So now that doesn't differentiate whether it's an at fault or a not at fault, but nonetheless, it's costing the WCB system $43,000 on average. And why that becomes important is, of course, we all understand WCB is an insurance program, right? So, the more, just like your car insurance, the more claims and accidents that you pay, or that the employer or that the car insurance company has to pay out on your behalf, the more your premiums are. Same thing with WCB. So the more money that WCB has to pay out on your behalf, the more your premiums are going to be. So what this slide then tells us is, and I'm sure that I know that you guys are a very forward-looking association, and these are things that should be addressed. So, do you look at, safe driving practices, or, defensive driving, or whatever it is? So basically what we're saying is the area in WCB that's seeing the most sort of claims draw from your area or from your association is the motor vehicle accidents, and that's probably where you need to spend your time with, right? And and then it looks at things like falls and body exertion and overexertion. And what's sort of interesting is we attended a seminar for another group, I want to say a few weeks ago, for continuing care. So those are the operators of long-term care facilities. And as you can imagine, they are sort of at the forefront of COVID type stuff. And interestingly enough, their COVID was starting to creep up for them, but their number one thing was falls, right? So, where, a nurse is trying to help a patient, and for whatever reason, they slip and fall and hurt themselves. And that was, and they had actually addressed that quite well, in that they had actually made that the focus of their sort of upcoming safety program. They called it, was it Fall Prevention Month, I believe is what they called it. So it was kind of interesting that it sort of coincided with that way. And again, this is just sort of informational purposes, but having worked with employers within industry in the past, I know that this is something that you guys probably will focus on.
Just to interject quickly, Tom,
Sure.
Energy Safety Canada can pull sector-specific reports with this type of information, the average cost, the average duration of claims for, let's say, a drilling sector or Code 6306, the vac truck sector. Those are available for any of our members if they want it. And we can actually do a comparison for an individual company. So we can look at your company, for example, and trend over the last 10 years how you have done in cost per claim and benchmark that against the rest of industry. So if anyone's interested, that is a service Energy Safety Canada does offer.
Excellent. Yeah, and it's a great point, Andrew. In that, and I would highly recommend that you guys, that all the employers here today, take advantage of that, because how do you need sort of that roadmap to help you to see where you are and where you want to be, right? And it's so many great statistics and so many great reports. Okay, so speaking of which, the next slide that we pulled, again, same type of information, but now these are the common types of injuries. So as you would suspect, sprain strain is the number one injury that your industries face. And quite frankly, it's pretty consistent throughout all employers at WCB. Sprain strain tends to be the big one. So, and sprain strain is such it's a wide range of things. It could be from the very mild stuff to absolutely serious stuff. Like, I mean, we all know that it encompasses the soft tissue injuries, which are challenging, can be challenging to deal with. We all know of cases, like, for the most part, sprain strains wrap themselves up relatively quickly, but there are those few that kind of stick out in your brain where someone had a very innocuous injury and now it's turned into a 6-month ordeal kind of thing, right? Anyways, the whole purpose of this is just to show you, where your common injuries are, and perhaps, you need to focus your efforts on reducing, sprain strain, like whether it's providing people braces or proper, um, other equipment that they need to help to prevent those type of injuries. If I could have the next slide, please. All right, so the topic of the day, COVID-19. So obviously forefront in everybody's brains, and of course with the announcements that the provincial government just put out yesterday with the strengthened restrictions and whatnot. So in terms of WCB, so in September of this year, WCB announced their cost relief. They'd been talking for a little while about developing a cost relief plan in relation to COVID-19. And in September of this year, they finally sort of released that. So sort of the key facts around that was, so it focused around the actual provincial shutdown. So the provincial shutdown as it existed happened between March 16th and June the 12th. So in between those dates sort of becomes critical. So, the one key thing is WCB says, regardless of the cost relief given, and all of those type of things, the worker benefits will not change. So what they're doing is since they're providing stability to workers, saying, hey, you know what, if you have these types of injuries and COVID related stuff, we might be doing some things in the background to help the employer, but at the end of the day, the benefit to the worker will remain the same. Okay, so they came up with a few different things on how they're going to deal with cost relief, specifically between those two, like I mentioned earlier, the provincial shutdown dates. So first off, they are providing cost relief on all COVID-19 claims. So if the claim is someone contracted COVID-19 and it's shown that it's a result, so here's the tricky point, is it has to be a result of, the exposure at work. I think that would make a lot more sense for someone, or it's much more relevant or much more readily available, or happens much more in, say, a healthcare setting. But nonetheless, they've said that they will provide relief on direct COVID-related claims. They also said they will provide relief on modified work. So as you know, modified work, somebody is on a WCB claim and now you're sort of slowly reintroducing them back into the workforce. And because of COVID shutdowns, modified work wasn't available for a lot of employers. So what WCB has said is, okay, well, we will provide, if you weren't able to provide modified work in between those provincial shutdown dates, you'll get cost relief. The kicker to that one is they would have had to have already have been in modified work. And once the provincial shutdown ended, you had to have re-offered them the modified work. And I believe it was within a 2-week period of that shutdown. The next one is if the worker became fit for modified work during that shutdown period. Again, the same ramifications that there had to be a valid offer of modified work in that time frame. And then when the world sort of started up again after June 12th, again, within 2 weeks, another valid offer of modified work. Another big one is delays in hospital admission. So if you remember that time frame, the hospitals were, they were getting ready for potential huge surges in COVID cases, right? So they had to delay surgeries and other treatments and whatnot. And what WCB has said is if your workers sort of, as a result of a claim, became their recovery period became longer because they weren't able to access, surgeries and treatments and all that kind of stuff, WCB will look at relieving all those costs. Now, WCB has said that they will automatically do those things for you. You don't have to do anything. But I think we would like to recommend what we like to call a trust but verify approach. So trust that WCB will do it, but at the same token, double check just to make sure, right? So trust but verify. Okay, if I could have the next slide, please. All right, so I thought Bill 47. So Brandy had talked about this a little bit earlier today. So Bill 47 is the new bill now. It hasn't passed as of yet, as far as we know. It's still in the second or third reading stage, but we suspect that it will pass. So there's been a number of changes. First one is that they're proposing is the changes to our office, the Fair Practice Office. So as Brandy had pointed out earlier, the Fair Practice Office itself will close on or before April 1st of 2021. And both of the advisory services are moving to the Appeals Commission. At the end of the day, the intent is to provide the same service. It'll just be under a different corporate name and different contact information. So the great news is the government recognized the value of the service that specifically the employer's branch is providing. So remember how Brandy said that the worker services existed in some form or another for 30, 40 years, but it's only the employer services only existed since December of 2018, right? So only a couple of years. And WCB or the government recognized, hey, you know what? Employers are funding this whole system, but yet they get no benefit in that they have no representation throughout this process, right? So, they've righted that ship and glad that they are seeing fit and continuing on the service. A number of WCB legislation related changes, Brandy already mentioned, so no presumption on psychological injuries. So prior to this bill, if it was shown that someone had a psychological injury and if they had an incident, some sort of incident at work, it was automatically assumed that the psychological injury happened as a result of work. And now the other side had to show the contrary, right? So it kind of puts the employers behind the 8 ball. And as you can imagine, if any of you have dealt with psychological injury claims, they can be quite tricky and they tend to be fairly lengthy. They're not like a broken leg that resolves after about 6 weeks. They go on for long periods of time. Another great piece of news with these legislation changes is there's no duty to accommodate. Now, that being said, as the employer, you still have a financial incentive to bring people back to modified work because remember, the more money that you pay or the less money that WCB pays, the better impact it has on your premium. But the problem is that we found is when employers were forced to do that, especially in this economy where it's a very tight economy, right? Everyone's sort of seen their businesses shrink and demand drop off, we heard of a number of cases where employers, because of this duty to accommodate, had to lay off or let go a perfectly healthy worker because they had to accommodate an injured worker, right? So that was, that's not fair to the employer, right? So as the employer, it's your business and you should decide who gets to work for you and who doesn't get to work for you. Obviously, there's some limitations within that, in terms of charter of rights and those basic human type stuff. But at the end of the day, it's your business. You should be able to decide that. And that's what I think that this duty to accommodate helps recognize. Another big one is employer health benefits. So under the current legislation, when somebody was on claim, you have to continue to offer them health benefits through your third-party provider. And those of you that have dealt with those type of contracts before, they're not easy to switch people in and out. And we know of cases where employers actually had to lie to their providers to say, yeah, this guy is still working here, because the way the contracts are set up, that only active employees can have the benefits, right? So this new legislation recognizes, hey, first off, WCB is not in the business to provide this type of stuff, and this is beyond the purview of WCB, and it's an unnecessary burden on today's employers. Another great one, for those of you that are aware, WCB used to do something called surplus distribution. So that should be coming back in the near future. So for those of you that don't know what surplus distribution was, so as you're aware, WCB, your premiums are used to fund the whole WCB system. It's a not-for-profit, and back in the old days, if WCB had extra money, it went back to the employers, because remember, WCB is a not-for-profit entity. So when the last government came in, they said, hey, wait a minute, this money that WCB collects is actually held in trust for workers, so we're going to put a stop to that surplus distribution. Now the current government's come in and says, hey, wait a minute, that thinking is wrong. This always was the employer's money. Yeah, we need to fund, that the workers have, that there's money in the kitty, so to speak, to pay for injured workers. But at the end of the day, if WCB has extra money, that needs to go back, because WCB is a not-for-profit provider, right? So now, that being said, I don't think there'll be surplus distributions this year because, well, there has to be extra money. And this year being the most interesting year of all of our lives, I don't think there's going to be extra money lying around. And if I was a betting man, maybe not even next year, because it's still the tail end of this. But I think for a couple of years down the road that those will start to come back. And good news for employers, right? So another big one Brandy had mentioned is they're returning the cap on compensable earnings. So the previous government removed the cap. So essentially what they did is they put a cap on the money coming into the system, saying, okay, as employers, you only have to report up to the maximum, which was, or it still is, $98,700, or is it $98,800? Anyways, $98,000. But they said, okay, but there's no cap on the money going out. So if somebody was earning, $300,000 a year, and then, WCB would compensate them at that level. And I think the current government realized, and it doesn't take an accounting wizard to realize, hey, wait a minute, if you've capped the money going in, aren't we going to run into a problem down the road if we don't cap the money going out? Like, there's going to be a stability issue down the road, right? And this current government says, hey, yeah, we need to make sure above all that WCB is a fair system, but that it is a sustainable system. So we don't run into a situation that a few jurisdictions in Canada ran into about 10 years ago, where they had billions of dollars of unfunded liability and had to go back to the employers and hit them with these special levies, right? So by doing this, WCB is putting themselves back in a good position where those kind of things shouldn't occur.
And Tom, that's particularly relevant to our audience today and our sectors, because our insurable earnings are typically higher than the average
Absolutely,
other
yeah.
industry.
Yeah. Oh yeah, absolutely. That's a huge one. And I think for me, coming sort of from the employer side of the business, that's the one that really kind of, stuck out at me. That and the surplus distribution. Those are the two that really kind of stuck out at me.
Tom, will that change to the cap be retroactive or only uh, going forward when the
Uh,
legislation changes?
yeah, more than likely, I think Brandy already typed in, but it'll more than likely, it'll be sort of going
Ah,
forward basis. They won't make it retro. And again, officially the legislation hasn't passed yet, but once we suspect it will, obviously they'll put out some information about that. But yeah, it'll be sort of on a go forward basis. The next thing I want to quickly talk about is they also made some changes to OH&S legislation. Now, I preface by saying that I'm not an OH&S expert, so I don't have a big understanding of the changes there. Our best recommendation is contact your health and safety people who would be very much in the know of what's sort of happened with that. But the big one that I can sort of comment on really quickly is specific to employers, to job sites that had multiple employers. And apparently there was a requirement under previous legislation about safety meetings, about how they had to be conducted and where they had to be conducted, all sorts of stipulations on that. And now they're making some changes to that to streamline it for employers. So you know how the government of the day has been talking about red tape reduction. That's been sort of a big focus of theirs. And this is sort of their help with employers in that regard. If I could have the next slide, please. So this one is just talking about sort of future engagement. So thank you for having us today, and we're hoping that you liked what we had to say and you like us and you want to bring us back to future ones. Any future ones we're happy to participate in, and if you can, let your membership know about us, and maybe include us in some of your, maybe on your web links on your website or any of your materials. At the end of the day, we are willing to work with you in whatever, in pretty much any fashion to sort of help get the message out there that we are there. We are here to help, right? We are WCB experts, and we are here to help you folks. And if I could get the last slide, please. So this is, I'll put a little caveat. This is our current contact information. So if you need to get, if you want to talk about something, and if you want us to review a particular case or whatever, this is how you get a hold of us. Once the information changes, so once we move to our new actual locations, we get new contact information. Of course, we will update all of our people with the new information. With that, I think there was a question I saw pop up.
Yep, from Wes. Are the caps different for the industry rate groups?
No.
So if you're talking about like the compensable, and yeah, no, that's static across the board. Yeah.
So one thing that I just wanted to comment on, Andrew, is that I will put our general mailbox for our branch in the chat. So instead of using this email, you can just email directly to our branch, and I'll put that in there. And so the next question was, how many advisors work in the office? So currently right now we have 3 advisors and 1 case assistant.
Apologies for the phone ring. That was me. The challenges of the home office. Okay. All right. I did get a private question here sent to me, and it actually goes back, I think Tom had mentioned this earlier. Can you maybe expand more on what you would recommend for when an employer is approached with an employee who has attended or reported late? How does that impact the reporting guidelines? I think it has to be reported within 72 hours in Alberta.
So it's 72 hours from when the employer becomes aware.
So not from the event time. So,
No.
okay. All right. Okay. We'll be sure to include that in our communications going out, because I know we do have a number of employers who do comment on that. You know, the guy gets hurt Tuesday, he doesn't tell us until, you know, Thursday. So, all right, very good.
And I was going to say also, WCB has also kind of said that, you know, that rule about the 72 hours is, you know, if it's reasonable that, you know, like basically the only look at starting to hit you with fines and penalties is if there was an attempt to hide or obfuscate. But if it's, you know, sort of, it came, you know, if it came because the worker didn't let you know in time or whatever, they tend to not to hit you with those type of things.
Okay, very good. Thank you for that, Tom. Well, I do think we're going to wrap up just a minute or two early. Unless anybody has any further questions, please do pop those into the chat. But just to talk about some upcoming events, we do have a BC virtual safety seminar. Now, this is a little longer than our typical lunch webinar from 8:30 to 3 on December 15th. We have a number of speakers who will be in attendance. Bud Phillips of WorkSafe BC will be giving his pre-drill session presentation that some of you are used to. So please do sign up for that. Now, starting out in 2021, we also have January 13th, a presentation on fatigue and distracted driving, talking back to what Tom alluded to, driving-related injuries being a high claims cost for the oil and gas sector. So that is presented in conjunction with the Alberta Motor Transport Association. We're going to follow that up the very next day, January 14th, with a supervisor competency development webinar. Supervisor competency being forefront these days, and one of those changes from OH&S legislation, again, looking at competency. So please do sign up for that. And then we should have today, I don't know if it's actually up right now, but it will be, the history of oil field safety with the Canadian Energy Museum. So that is out of Leduc, and you may know that as the former Leduc No. 1 Museum. So interested to see what they have, some safety history through the ages. And you can register for those at our website at energysafetycanada.com and then look under events. All right, and further, feedback survey. I will post the link in the chat to everyone, but you should receive a feedback survey within the next 15 or 20 minutes regarding our presentation today with both Brandy and Tom. So please do respond to us. Let us know what you thought of the presentation. How can we improve? And what topics would you like to see? Would you like to see Brandy and Tom back? So,
Andrew?
Yes.
Were you not going to ask the poll question?
Oh, that had slipped my mind. That's a great way to wrap up. Thank you, Brandy. We do have a poll here available for most of you who are still in attendance. Should be popping up. Prior today, did you know about the Employer Appeals Office? And we'll leave that up for another minute here, and we have a couple of more questions. All right, I'll leave that for another 5 or 6 seconds. We got most of you have answered. And most of our audience, 56%, have not did not know about the Employer Appeals Office prior to today, and only one has used the services. So, okay, so it's been some good information, I think. All right, and then follow up. How familiar are you with the WCB appeals process? And again, I think this might be a function of the size of the organization. The larger organizations are probably going to have more of an opportunity to engage with that particular process within the WCB. And somewhat 55% is our leading result there.
Actually, you know what, Andrew? We have found that just because a lot of the larger organizations don't appeal.
they just accept. It's,
They, well, yeah, and a lot of them have come to us for advice because, again, even though you have a person hired to manage WCB claims, it starts to get very complex when you're going through appeals, and there can be jurisdictional issues and all sorts of things where they don't know. And so they've come to us for help.
and you know, I will mention, you know, we do have a question here about the have you participated at an appeals commission hearing? Um, I have a friend who, a former coworker, who's an adjudicator at one of those hearings, and she actually turned me on to the Fair Practices Office for this presentation. And she said, "Gee, I wish more people who came in front of me would engage the Fair Practices Office." So that is why we ended up coming down this path and how we found you. So actually a 50-50 mix from the audience on participation in the Appeals Commission hearing. And then one final question, just as we wrap. If you've gained any new information on the services offered, after today, are you planning on engaging the office for any assistance? We'll find out if we can give you some more work there, Brandy.
We have lots. We're always open to more.
Yeah, well, job security is a thing we don't hear enough about these days with COVID and lockdowns. So.
Mm-hmm.
All right, a little over half the field responding here of our participants. All right, and maybe 7, and yes, for sure 2. So there is a few people here who are definitely going to be engaging with you further. So very happy to hear that.
Mm-hmm. Mm-hmm.
So, all right. Unless we have any further questions, I'll just pull up the chat here. I don't see any. I think that will wrap up our presentation today. Thank you, Tom and Brandy, so much for your presentation today, and look forward to chatting with you again.
Yeah, thank you for asking us to be here.
Thank you so much.
All right, take care.
Bye.
Bye-bye.